Thank you, Scott. Thank you, colleagues. Very grateful to be here, although I think it's only right that I start with the bad news, because there is some. And that is that Aidan O'Neill, the leading constitutional lawyer, said yes to doing this, but couldn't make it. John Hendy, QC, the godfather of industrial rights and collective bargaining cases, said yes, but couldn't make it. Sadly, I said yes and could make it. So you're stuck with me, colleagues. I'll do my best, though. And I have been, as Scott said, asked to talk about constitutional issues regarding devolution of health and safety. And I'll do my best in that. I actually think that the main issues are around the politics of it and the economics of it, rather than constitutional issues. But what we are talking about, really, at a constitutional level, is effectively amending the Scoland Act. That's where the rules are contained, and that's what we will need to do to see the devolution of health and safety. And as Ros says, and I agree with her on this entirely, the entire suite of powers that relate to employees. So to do that, we need to amend the Scotland Act. And of the Scotland Act is section 29. That is the section that identifies what areas are reserved matters. It says that an act of the Scottish Parliament is not law if it relates to reserved matters. So that's what we're talking about. Reserved matters, of course, are those few powers, or perhaps many powers, depending on your perspective, that Westminster held back. They're contained in a list that is Schedule 5 to the Scotland Act, and it contains all of the powers that are held back and reserved to Westminster, and therefore in relation to which the Scottish Parliament has no powers at all. And of course, as you can see there, what we're talking about here is Head 2, Health and Safety. That is the subject matter of Part 1 of the Health and Safety at Work Act, as well as Health and Safety Commission, Health and Safety Executive, and the Employment Medical Advisory Service. Let's start, however, with the Health and Safety at Work Act in Section 1. And what that means really is absolutely everything that relates to the things that we would want to do in relation to legislation that impacts in workers' rights. That is, if it was legislation in relation to making workplaces safer, legislation to impose sanctions on employers for breaching health and safety, legislation to ensure fair compensation if workers' rights are impinged. All of those matters are reserved to Westminster. We look back at section 29 then for any idea as to what relates to reserved matters means. And you'll see that's contained in subparagraph 3 here, where it says in entirely clear legislative language, as it always does, that a question as to whether a provision of an act of the Scottish Parliament relates to reserved matters is to be determined, subject to subsection 4, by reference to the purpose of the provision, having regard, among other things, to its effect in all the circumstances. So there is what Parliament says is the test, and over the years that's been fleshed out through court actions as to what that actually means. Initially, all of the talk in relation to that section turned around what was referred to as the pith and substance of the legislation. What was the pith and substance? If it was about a reserved matter, then it was reserved. And that was a term that the late, great Frank McGuire would regularly refer to when he butted heads with civil servants around corporate legislation. But I'm sad to say the UK Supreme Court, through various decisions, has said, in fact, that pith and substance has nothing to do with it. And Lady Hale, and you can look this up on the internet, gave a very helpful speech to the Scottish Public Law Group in 2018, where she summarised all of the case law that there had been. And she said that there were actually 4 tests by which the courts look at and determine if, having regard, among other things, to the provision, the effect in all the circumstances is to relate to reserved matters. And those 4 tests are here. She says, firstly, that relates to means more than a loose or consequential connection. The court said that when you look at the effect, and this one's particularly good and clear, you must look at more than the objective consideration of the effect. I presume that means you must actually have to look subjectively at what Parliament intended as well. The courts have also said that where there is more than one purpose to a provision, that if one of those purposes relates to a reserved matter, then the entire section or act falls, unless that purpose is entirely inconsequential. And fourthly, just to really rub it into poor Frank's arguments, that it has nothing to do with pith and substance. So I'll now end the world's worst in a low tech PowerPoint and return to the screen. I don't know if that's a good or a bad thing that you're seeing me again, but there you go. But I suppose with that quick skip through what the courts have said and what the Act of Parliament says, you'll see that's really quite clear cut. It's pretty black and white as to what is a matter that's reserved to the Scottish Parliament and what is not. It's just clear, isn't it? Am I right about that? If any of you think that, by the way, you should all jump straight to the Supreme Court, clearly, because as far as I'm concerned, it's about as clear as mud. And what you can see, in fact, is that the way the Act is framed, that the way that the courts have interpreted it, is that there's lots of scope to argue, lots of scope for lawyers to come in and argue about whether or not a particular piece of legislation is or is not within those general rules. And to be honest, that's something that I have always called for, way back to 1998 when the legislation was brought in, back to when I was a baby lawyer. I've always said that if the Scottish Parliament had one duty, if the Scottish Parliament had one obligation, it was to push the boundaries of the devolved settlement as far as it could. That it should be pushing at those boundaries, bringing in legislation that forces the provisions of the settlement to be extended through legislation. And there's been some examples where they've done that, and they should be congratulated for doing so. I'm thinking of the smoking ban, I'm thinking of the emergency workers legislation, and of course they tried it very recently too in relation to the right of the child. So there have been instances where the Scottish Parliament have attempted to do that, to push the boundaries and to stray into those grey areas. But sadly, there's also been far too many areas where they've not, where they've been far too cautious, far too, dare I say, to use an inevitable pun, far too reserved in their approach to these matters. I'm thinking of corporate homicide, where Parliament session after Parliament session, members' bills have been brought forward and ignored. I'm thinking about a bill that was brought in to try and get around Section 69 of the Enterprise Act that Ross referred to, when the argument was that the EU directive should apply directly. Again, that didn't get off ground one because of, frankly, the dead hand of the civil service and because of issues of political manoeuvring in relation to the powers that be at the time. There's actually been one very interesting piece of legislation where the Scottish Parliament have done what I'd describe as a constitutional parliamentary competence flip-flop. And it's far enough apart that many people might not have spotted this. You'll have seen, and I certainly welcome, the fact that the Scottish Parliament are to introduce powers to effectively renationalise the rail line, to take back the franchise from Abellio. But what some of you may not know, and I only firstly became aware of these new manoeuvres when my pals started phoning me up. Not pals within the movement, actually, not pals who are lawyers, but just pals in the real world, because they remember years ago I was telling them that when Tommy Sheridan tried to do the same bill 15 years ago, I drafted that bill for him. And we drafted a bill that set out why and how it was competent within the powers of the Scottish Parliament to renationalise the railway. That bill did not get off stage one. It was voted down at stage one. The general principles of the bill were not agreed on the grounds of legislative competence. Fast forward 15 years and we have a flip-flop, and the Parliament have suddenly decided that they do have those powers. So again, that just shows you how and to what extent, if there is political will, a way can be found. And that's the real problem here, that what we're facing generally is, as I said, the dead hand of the civil service and political manoeuvring. And of course, on one level, that's understandable. This is all about politics. To my mind, however, while it's perfectly legitimate for politicians and for political parties to make decisions about what policies they'll pursue, which bills they'll support or not, that is politics. But what I don't think is acceptable is for them to hide behind the Scotland Act and to hide behind legislative competence when they do that. And if we were to see the Scotland Act amended for health and safety law to be devolved, then that would no longer be open to any politician of any colour to do so. So when I say, should the Scotland Act be amended, it's a resounding yes. How can that be achieved? Well, leaving aside the fact that it would require a act of the Westminster Parliament, and that's what we're talking about here. It's the only way it could be done, is for Westminster and for the Tories, as things stand, to introduce that act. Then if we just set that aside for a minute, what other challenges we're facing really relate to potentially legal aspects and economic and political issues. The legal one, again, has been set out in some of the cases, in particular an opinion by Lord Hope in a case Imperial Tobacco. I'll not jump back onto my Word document, fear not. But in a nutshell, what he said is that the powers that are reserved to Westminster generally are those that allow the free movement of workers within the UK, that relate to UK-wide constitutional and conventional obligations, and that allow the internal economy and internal market of the UK to operate. So you'll see instantly that some people will try and make arguments that that must mean that employment law, that health and safety law should not be devolved for the reasons that Ros set out so powerfully in her contribution today. Will it cause employers to relocate out of Scotland and elsewhere? Will it cause insurance premiums to rise? Will it cause claims to increase in Scotland as compared to the rest of the UK? Will we see more red tape for Scottish businesses? In short, no. I mean, I can be absolutely categorically clear about that the answer is no, because there's been many times over the years where, not in black letter law, but in matters of substantive procedure, where there's been significant differences between the position in Scotland to the position in England and Wales as it impacts on employment claims and health and safety law. When Labour came in, they introduced, back in '97, they introduced a form of reforms called the Wolf reforms that only apply to England and Wales. They made it significantly easier for trade unions and for trade unionists to pursue civil claims. That was then flip-flopped when the Tories came in with the Jackson reforms. But that made not one iota of difference as between Scotland and England and Wales as to the levels of claims or the extent to which people actually grabbed and enforced their right to seek redress through the courts. Not one business moved anywhere. So red tape, colleagues, is a myth. And frankly, and I'll go further than Rose did, if any employer did genuinely feel the need to relocate south of the border because they'd be scared by any legislation that we would bring forward here through health and safety powers, good bloody riddance to them, as far as I'm concerned. And the reality is, what the real consequence of health and safety laws being devolved to Scotland is that our workplaces will be safer, our workers will be far safer, that families will be less likely to lose a loved one because of callous and corporate killing. and that can only be a good thing. Scotland, colleagues, if we devolve health and safety law and start to bring forward legislation such as that repeals Section 69 of the Enterprise Act, such as corporate killing, will not be a hindrance, will not scare people away. It will shine a light to the rest of the UK. It will shine a light to civic society throughout the UK so that others demand a equalisation up, not a race to the bottom. And that can only be a good thing. Colleagues, thank you for your time.